When dealing with real estate, you're dealing with contracts. And when you're dealing with contracts, there's always the potential for litigation. Today, we're going to be talking about how not to get sued in the world of real estate today on the Brian Hurst Show. Well, good afternoon, everybody, wherever you may be. I hope that this Monday finds you well. Juneteenth, 2023. The California Association of Realtors has a residential purchase agreement. And anytime you see the word agreement on a document, it means it is a contract. And there are clauses in that contract that necessitate performance for both the buyer and the seller. And of course, there's always potential that one of the parties will not perform on their contract, which opens up the possibility to litigation. You'd have to hire a good lawyer. Well, the best lawyer and the finest legal mind that I know is our special guest today. I'd like everybody to please welcome Mr. David Greiner, Esquire. What is up, my brother?
How are you?
Blessed and highly favored. What do you think of my Hearst Team Realty hat there?
I think it's fantastic.
Yeah, guess where I got that?
I'm aware. He does a good job.
Doesn't he, though?
Mm-hmm.
Yeah, and I gave away a bunch of these to, I got that idea from you. It's never hurtful to have your brand out there everywhere on the golf course. Am I right or am I right?
Especially if it's so fashionable.
Actually, it's so what?
Fashionable.
Oh, yeah. Well, I'm just trying to keep up. Look at you.
Big day.
You even have a vest on today.
Yes, it's a big day today.
Oh, you're looking good.
Thank you.
Dave, tell us a little bit about yourself and your journey into law practice.
Yeah. Well, thank you. And thank you for having me. I graduated law school in 2003, passed the bar in 2003, and immediately kind of came home to help my father run the family business. Did some law practice in doing that, contracts, and we did some buy-sells together, but mainly just served the family business in that regard. My mother's side of the family comes from a long lineage of lots of lawyers. So it was kind of a family rite of passage to become a lawyer. My mother has a sister and two brothers that are lawyers. One of her brothers married a judge. They have 3 children, they're lawyers. And the other brother has 2 children, they're lawyers. And so it was kind of a rite of passage to become a lawyer, even though it didn't seem like that would be my immediate path or if it would ever be my path. So that's how that happened.
That's remarkable. And you're great at golf. Like, how do you do all that?
How do you do it? You're too kind to me.
That's true.
And
I'm just telling the truth.
I don't know, with some of our friends, mutual friends, that said, hey, I would like you to help me with some corporate law and some real estate law. And that happened for the first time around 2012, where somebody else was asking me to do something. And what happened is when one of those clients sold their business, Brian, what happened is at some point, a lot of people who worked there left. And they all had my cell phone number. So instead of having that one client, all of a sudden I had lots of clients with real estate issues. And so when we sold the family business, that was a natural first start for me as far as my legal career. And it dovetailed right into probate practice because so often we run into that in real estate where we need to probate a part of, the real property. So that's how I got here.
Yeah, we talked a little bit about one of the earlier episodes with, I believe it was Bobby Tarango. We talked about, why you should create a trust.
Sure.
And that's probably, another topic of conversation that we should have you on to walk us and help us get our minds wrapped around the nightmare of people going through probate it's a tough situation, and we can avoid it just by being proactive. You have been especially helpful to me personally, and have helped me navigate through some, sticky legal issues with real estate contracts. And you have a remarkable mind for real estate, uh, almost as though you had a real estate but you don't have a real estate license,
I do not. Mm-mm.
but you have an incredible mind for real estate and real
I
estate
appreciate
contracts. And that's just a product of having walked some of your friends through legal issues vis-a-vis real estate.
it. And yes, for sure, is familiarity with it, but also a pretty strong basis in contract law.
Mm.
That was pretty, although we don't have specialties per se in your initial schooling for becoming an attorney, I was very close to my contracts professor, and ended up being a research assistant to him too. So contracts were certainly a place that I excelled in prior to leaving school. It was almost exclusively what we dealt with um, in the family business. And then I was a amateur in real estate law at my school too. So that basis is what's maybe giving me the ability to do these things with the real estate.
Interesting. Okay, a couple of things I want to dive in with you as it pertains to that purchase agreement. The first would be performance. Let's talk about, scenarios in which one or both parties aren't performing, and what are some examples, and how that could open up a world of difficulty for people.
So, and maybe you agree with me, the car form is a beautiful instrument.
Mm.
If done properly, it keeps the parties on track
Right.
to close. It is truly, I mean,
Mm.
well done. So if you talk about the day that you sign an offer, right? Well, actually, let's start with the listing, right? You list a property, which in and of itself is actually an offer, right? It's a solicitation for an offer, which constitutes an offer. And when somebody submits that offer to you, when you accept it, and that offer is our agreement that we're talking about today, right?
Yes.
Standard, residential purchase agreement, offer, and joint escrow instructions. You submit that, and they agree to it. Maybe they counter it, which would be a death of the first offer and a new offer. That's what a counter is, right? But at some point, two people sign the same set of terms, right? And at that point, you have a contract.
Yes.
Yeah, and that's kind of when the magic happens, right? Because you're going to possibly have contingencies, like the standard form contingencies of 17 days to inspect, or appraisal contingency, maybe a loan contingency, and sometimes you don't have them. But in English, a contingency is something that must occur before you have to perform.
Mm-hmm.
And in the law, it's called a condition precedent, which means it's a condition that must happen first. So that's kind of the first beautiful point, right? And you have this many days to make yourself comfortable with whatever that condition might be. And then at that point, you're going to be asked, or should be asked, to waive it so we can move forward. So that's how we stay on track, And one of the preconditions of that is also receiving your seller disclosures, right? Right off the bat, the seller should be giving you the seller disclosures. And you should be examining those along with your own inspections. So that's a beautiful thing in and of itself, because both parties should know within that period, whether it is 17 days or longer, whether or not they're going to go forward.
Right. This is one of the reasons why I tell my clients long escrow is a bad idea. So sometimes they'll say, we really like a 45-day escrow, whether it's the buyer or the seller. Sometimes the sellers want that because they want more time to get their things together. My argument with that would be you should have already had your things together once you decided to sell the house. But I digress.
And between you and me, let's say we had a 45-day escrow, but the contingency period isn't any longer.
Exactly.
What does that do for them, except that they just don't think they'll have their funds in time?
Well, then we need to know that up front. And,
I agree.
And this is this is where it gets sticky, right? So you pointed out, so when I first started in real estate, I worked with gentleman who's now a fellow broker in our business, John Hess. We sat in the same office over there in the old days at Sheer Realty back there, where my mom's office was. And I remember him saying, "Look, everybody can avoid all kinds of trouble if you just follow the contract. Just
Right.
follow the contract." Now, this is where I'm hoping we can help our viewers. When you go under contract, you've got, like you said, these contingencies, these mile markers. The first one is you got to get the EMD, and you have 3 days to do that. You don't get the deposit in.
Sure.
And if the buyer fails to perform, then the seller can issue a notice to perform, and they now have legal grounds to cancel the contract, because without consideration, we don't really even have a contract. But then you've got these other, right? The inspection, the appraisal, and the loan that you mentioned. And whether the escrow period is 30 days, 45 days, 90 days, or 190 days, those contingencies have to be met in that time period. And once those are met and removed, there's no passive removal. You have to actively remove them. Why else would we drag on? Only bad things can happen, right, with the contract after that.
Right. And so if we stay on track with it, you're going to avoid a lot of problems. One thing I see sometimes, I don't know if you see this, is that if we don't take the time upon that, let's say it's 17 days, okay? Because it's a lot of times 17 days for condition.
That's actually baked into the contract.
Yeah, unless you check the box and say, "Oh, I'm giving you 45 days or something." But if we don't take the time on the 17-day mark to have the conversation and remove the contingency, some of that beauty of this contract starts to get lost.
It does.
Because now it starts backing up on us.
Right.
And what I've found before, I don't know if you've seen it, but all of a sudden we're past the closing and all the contingencies still remain intact.
Right.
And so now what do we do? I mean, that's when we have all kinds of issues.
Well, here's the, the California Association of Realtors and, the real estate legal powers that be in the state favor the buyer. I mean, heavily. And essentially, so long, the big one is that inspection contingency. It's like a junk drawer contingency.
Right.
That so long as it remains in place, you could be in the 135th day of escrow. If that contingency remains in place, the buyer can back out because they had bad pizza the night before and they don't feel like buying a house before, and there's not a darn thing the seller can do about it.
It's just a bad practice, right? To not have that conversation. And I don't know if you've heard this before, but I had an agent tell me one time the reason they don't do notice to perform, be it from the seller side or the buyer side, is because they don't want to offend the other agent.
Yeah, they don't want to tee them off.
Yeah, but you're not doing any service to your client.
Right. You're failing to act as a fiduciary for your client.
Yeah, because let's say your client is having reservations on day 15.
Right.
You have the conversation, "Hey, contingency period's coming up. What do you think?" And they're like, "I really don't know if I can live with the staircase falling down, Brian." Well, then say, "Let's get out of this and do everyone a favor," because we're still within our contractual rights. Instead of kicking that can and creating tension in the process.
And so this is what we've discussed so far with performing on the mile markers in the contract all the way down to actually closing the deal. The failure for a real estate consumer to perform is really a function of the agents not being diligent.
Could be.
Because the agents should be the ones to know, right?
Could be, yeah. I mean, I love the real estate agents too. I don't know why this happens, but
I'm just telling you, having done a few hundred deals.
Yeah, more than I have.
Always the agents. So for me personally, this is just Brian Hurst's way of doing things. And I was trained by my mother, and Paula, that she's, there's a reason why she was a perennial top 5 agent in the desert for 15 or 20 years or whatever it was. If I have the buyer, okay, I just tell them, okay, the most important week of escrow is the first week. And we got to do three things. We got to get your EMD in. We need to get your appraisal ordered, and we need to get your home inspection scheduled. And if you'll just do those three things right off the bat, as soon as you go under contract, you're going to be able to check those mile markers. But what happens so often is the buyers kind of are like, well, we're not sure. And can we do this first? And they're just kind of lazy about it. Then we have a problem, man. I mean, we get to day 17 and that seller's, they're on the edge of their seat. They don't know what to do. And you could have demand for performance and people getting angry and uptight. And we could avoid all that just by following the contract.
Yeah. And why I get so many of these buyers waiving inspection or not inspecting the house beyond me. The contract is heavily worded as an as-is purchase. And
right.
If you don't inspect, there's a legal presumption against you if you do have to go to court that you would have found out about this and that you bought it knowing about the condition. So I don't understand why they don't want to inspect the property. I think that's a reasonable thing to do is to look at what you're buying. Maybe it's because we're preconditioned from the products we buy. We have so many protections with products that we think, oh, well, the house should work. But real estate is a common law area of the law. It does not have consumer protections. And so you really do need to do a diligent inspection as a buyer. And that TDS stuff where they try to hang up a seller on the failure to disclose on the transfer disclosure statement. I shouldn't use acronyms.
I was going to say, just for our audience, tell them what a TDS is.
A seller is required by the civil code to provide a transfer disclosure statement to list the known material defects of the house. But that document, just like the rest, is supposed to merge into the purchase agreement. It's when a buyer discovers that he can't live with one of those things that's disclosed, their remedy is to get out of the agreement. It's not to buy the house and sue them later. And so I think the buyers really need to understand that if it's not a brand new house, there's not going to be any statute protecting you. And so you got to make sure you're comfortable with how that house is sitting.
Well, the segue is, and I presume that people would remove, I mean, I don't see this too terribly often. There's no way I would do this, okay? Unless I'm dealing with an extremely sophisticated buyer who's willing to take on that risk. But if somebody did remove the inspection contingency, and the way I explain it is that the word contingency can be supplanted with the word if. So you said what's a preceding condition?
Exactly.
Right? And to shorten that down, it's the word if, right? I'll pay you $400,000 for this house if it appraises for $400,000. If I successfully am approved for my loan for $400,000, and then that big one, the inspection, if I inspect the property, I'm satisfied with it, and we successfully negotiate terms,
right?
Because that is that, the buyer can further negotiate even after going under contract. I can further negotiate, inspecting the house and asking for a credit, reduce in price, or whatever it is, repairs to be done. If a buyer removes that, that's the big one. I mean, again, as long as that one's in place, that's the catch-all. Buyer can bounce for any reason they want, and even if you sue them, if they say, well, did they have their inspection contingency? Yeah, they did. Well, then, there's nothing you can do. I think the risk maybe they're willing to take is to call the bluff of the seller to sue them for failing to perform on the contract. And what does that look like? So I want us to move forward now with that clause in the contract that says liquidated damages.
Yeah, and that can be a big number when you get into bigger and bigger house prices, right? Because it can be up to 3%. And that's been upheld regularly, that 3% is not a penalty. It is recoverable as liquidated damages. So liquidated damages in general is, hey, we both don't know how much I would be harmed if you don't perform. So we both come up with a reasonable estimate of the amount of damages I will sustain if you don't perform. And that number generally is associated with the deposit.
Mm-hmm.
And what that means is for a plaintiff is that I don't have to prove damages anymore because the paragraph says we can't figure that out. It would be too expensive for us to figure that out. Therefore, by agreement, we both agreed today that this is the damages, which makes it a lot easier case for the seller. He just has to prove the breach now and not he was harmed.
Well, it could be the buyer too.
Yeah, it could be the buyer too.
This is the thing. There's no contingency baked into the contract for the seller.
No. Well,
so the seller, once you go under contract, that seller's married to the buyer.
Right. And it's a present promise. And that's probably the most the most misunderstood thing by individuals buying real estate is that the promise is the day of the contract. And it's subject to maybe some contingencies to get out, but the promise isn't a future promise, right? Because that wouldn't even be enforceable under law. The promise is today. I promise to buy it.
And I promise to sell it.
And I promise to sell it. Correct.
So hypothetically speaking, and there may be circumstances in which this is the wise move, the seller either will not or cannot deliver equitable title to the buyer. Because like you said, it's a present promise. And that's what you sign that contract. You're saying on day 30 of this agreement, I will deliver equitable title to Mr. and Mrs. Buyer.
Right.
And if either you cannot or you will not do that, you open yourself up to liquidated damages.
Liquidated damages, and in real estate, and we'll get on to the liquidated damages, but and in real estate, you can also open yourself up to something called specific performance.
Right.
Specific performance is a theory that if something's unique, then you have the right to have the court just hand it to you. And which means that if you win on a specific performance action, the court will go ahead and sign over the property for the seller and the buyer will tender payment.
And so in the case of, let's say we're getting down to, the last portion of a real estate contract. And I actually had this come up recently where there were like 5 sellers. And two of the sellers, the title search revealed in the 11th hour judgments against them. One of them was for like unemployment. The other one was child support, back child support or something like that. So the title company said, whoop, time out. We can't close on this until we get these satisfied. And if the seller cannot or will not do that, we have a situation where the buyer's agent, the buyer by way of the agent, would send a demand to close. So that's specific performance, right?
Yep.
And if the seller cannot or will not perform, we have a liquidated damages problem. And what you just said, that's up to 3% of the purchase agreement.
Yep. Yeah, that's right. Or your buyer could forego that and say, I'm going to court and I'll have the judge go ahead and issue the home to me. And then you'll get paid. Then your creditors are going to get paid out of the proceeds. Too bad. I mean, that's what it is.
Wow.
Not to mention breaching that contract on behalf of the sellers because you have a judgment you didn't disclose to anybody. Not to mention that their own agent can sue them for failing to complete the purchase.
Is that right?
Yeah.
Man, I learned something new every day. I did not know that.
Because they're that agreement, when you agree to list the property and accept an offer, that basically that you're agreeing to pay that commission, not just to both the procuring agent and the selling agent. And so, yeah, I mean, it's big bad news if that's the case. That's interesting you brought that up too, because you're talking about that kind of recorded judgment search. And we just don't get that early enough in the process sometimes. Because it's not against, it doesn't show up all the time in the preliminary title report. They have to actually search the county records to see if anybody has a judgment recorded against them, And so that's kind of what you're dealing with on that in that situation.
Yeah, it's sticky. So, the last thing I wanted to ask you about, Dave, is the arbitration of disputes. Now, in the purchase agreement, it used to be page 8. I don't know what it is now because they keep lengthening the car contract. It's 16 pages now, if you can believe that. But on one of the pages, there's a box and it has the 2 clauses. One of them is liquidated damages, which we've just covered, and then the arbitration of disputes. When DocuSign, that's the digital signature program I use that's connected with ZipForm, which generates the car contract. Okay, when I generate that purchase agreement, it will mark those 2 clauses in the contract as optional for the buyer to sign. But I know that if I want to get my offer accepted, I better have both of those initialed. Otherwise, it's likely to get countered. And if it gets countered, the door's open for another buyer to come in, offer better terms, and ace us out. So my training was back when I first started in this crazy business. And now when I train agents, I tell them, no, don't take the optional out of it and just populate those fields with their signature, because there's no way we're going to get the offer accepted without it. But the conversation that you and I had yesterday is that you're not sure. First of all, we need to define what arbitration of disputes is in the contract. And secondly, you said you're not sure that there's wisdom in initialing that and agreeing to it.
Yeah. So yeah, it's around paragraph 20 something, late 20s, where the arbitration clause is. Arbitration is a private court that decides disputes. And maybe it's a judge, maybe it's a lawyer, maybe it's an ex-commissioner. But basically, it's a less formal, more expeditious way to resolve a complaint. I can give you like an example of that would be is that you can send, an email to somebody and that'll be notice. That you have informal discovery. You just kind of send everybody everything you have. You don't have to do as much, requesting and depositions and things like that. And you don't have to check in on the court's timeline to make sure that you're on schedule for your trial. So the upside is it's a faster dispute resolution. The downside is it's private. So you've got to pay for it. And it's not cheap. Court's cheap compared to it, right? Court, the filing fee right now, that might be off by $1 or $2, is like $4.96. Arbitration, depending on the amount in controversy, is tens of thousands of dollars. And that agreement says that both parties are going to split that. So does your buyer have tens of thousands of dollars to arbitrate if they think they've been wronged under the contract? That's something to consider, because if you don't, it's not a viable option. And the other side can, if you try to sue them instead, can do, and I'm dealing with these nonstop right now, they can file a motion to compel arbitration, which they go in front of the judge and say, they signed an arbitration agreement. You can't hear it, judge. And once the judge says you're right, now you're both back to paying for this arbitration, or nobody gets any redress.
So my understanding up until this moment was that because arbitration is cleaner, simpler, faster, everything you just said, that it's also cheaper. But you're saying, in fact, it's not cheaper.
Certainly not off the get-go. It's not. And maybe over time it might be because of the amount of time expended the other way. But let's face it, if you file a lawsuit in San Bernardino County, one of the first things they're going to do is they're going to order you to court-sponsored mediation, which is going to be, free. So I mean, they're hoping you're going to resolve the process as you go and never get to trial. Arbitration is like a guaranteed way that you're going to end up in some sort of trial. Important note for all the clients out there is that, regardless of which way you go, there is a requirement to mediate in the CAR form. Mediation is not arbitration, right? Mediation is how I explain to people. Mediation is where both parties hire a third party to tell them both how bad their case is. And then if everyone leaves angry, you had a successful mediation. You got to do that first. And
right.
if you do that first, guess what? If you don't do that first, then you can't recover your attorney's fees in the later scheduled arbitration or court.
Is that right?
And then let me tell you option number 3 or door number 3, why arbitration, just at least worth thinking about of whether you want to do it or not, is as agents, you guys have separate duties to these clients, separate from maybe what their duties are. So if a seller has a duty to disclose something, the agents have duties as fiduciaries to investigate maybe, or to disclose depending on which side they're on, right? And it might be helpful if you had a proceeding where not only the buyer and seller were involved, right? But maybe you would also want the agents involved to see really whose fault is it that we didn't know that the well didn't work. Well, if you choose arbitration, the agents are not bound by the arbitration clause. So you could get yourself into a situation where you're arbitrating buyer and seller, and the agents are involved in a subsequent lawsuit pending the determination of arbitration. Wow. Now you get 2 proceedings. So earlier you had said something interesting, which is a lot of times it might be the agent and not the buyer or seller that's actually the one who caused the issue. Well, now you have to go 2 separate avenues to find your redress.
Well, the reason I said that is because that CAR contract is written in lawyerese.
Yeah.
And, those files, those real estate files are thick. I mean, there's a lot of documents. Okay. Like I said, the CAR contract alone now is 16 pages. And the more stuff that they add in there, the less people are going to read it.
I know.
And so they're just signing it.
I know.
Because they want, and for me personally, Dave, when I'm representing a client, I try to keep it simple by saying, look, do you want to buy this house for $500,000? And buyer says, yes, that's what I want. And I said, then just sign here, because, we're going to get into the deep weeds, me trying to explain every jot and tittle of the contract, that they're not capable, most of them are not capable of absorbing that information.
Yeah, it's too much.
Yeah, it is. It's too much. But as their fiduciary, like for me, representing them, I better know what the Sam Hill, the contract says, so that I can successfully coach my client through to avoid any potential of litigation. That's my job. So I need to know that if I have the buyer, that I got to perform on the contract with contingencies, and there comes a time frame where we need to remove those contingencies, and baby, we better get on the stick and get this thing done, or we open ourselves up to potential problems. So that's why I say that the agents more oftentimes than not are the ones creating the problems just by not following the contract that they wrote.
Yeah. So and you do such a good job on this show. I mean, you have such engaging guests, and today, hopefully I put them to sleep or then turn me off already with all this legalese. But what if we made it really simple for people? Like put it in complete everyday terms. Step 1, do you want to buy this house for $500,000? Yes or no? Yes. Great. Let's get this part executed. Step 2, you're going to get a number of documents, a number of advisories throughout this process. I would expect you to read them, but if you don't read them, what I want you to know that they say is, if this house is awful, if that garage is not permitted, if somebody's encroaching on your property line. If anything is wrong, it's your fault, buyer. You own it. So just know that that's pretty much what each one of these documents you're going to get is going to say, is it that it's not my responsibility as the agent, and it's not the seller's responsibility to make you comfortable. So in the 17 days, that's when the work's going to begin. So 1, do you want to buy it? Yes. 2, make sure you want to buy it now. Don't, it looks fine to me. Pay a good inspector, the guy who's going to go through each and every little bit of it. And even if you're not going to ask the seller to fix it, at least you know that it's there. If you think there's an encroachment, have it surveyed. You know, all these little things. If you think something's not permitted, request to see the permits. All these little things. If there's somebody living there that is not the person selling it to you, ask to see the lease. How long are they going to be staying? Who are they? I mean, these are things you got to, we're so used to not protecting ourselves anymore. We just go online and you send me something, I buy it, I eat it, I put it, whatever. But this is different. Everything that elicits something in your head, like, why is there someone living here that doesn't selling this to me? Ask the question, look at the lease, be comfortable with the whole thing in that period. So do I want to buy it? Make sure I want to buy it. And then either cancel or close.
Right.
And that would make it really simple, is if they focus very, very intently on what they think they might be getting.
Right.
That would save a lot of problems.
This is one of the things that, you know, when you have a good agent that can successfully navigate, in this case, the buyer, and have some client control, that's the term we use a lot in our business, in helping that buyer to navigate through what are deal breakers and what are things we can work with.
Sure.
You know, and so let's say there is an encroachment, and you may want to ask the seller to remedy whatever the encroachment is as part of a request and further negotiating. And if they can or won't or whatever, you decide, you know what, that is the house and I'm willing to live with that encroachment. You go ahead and move forward, but you're doing it eyes wide open. And yet, and every time I talk to you, Greiner, every single time I talk to you, I'm smarter as a result. So we all need people like you in our lives. I don't know if you've had some people where you feel like you're dumber after talking to them. But you are one of the ones I'm smarter after talking to. And you beautifully put it. Do you want to buy this house for, and we're throwing out this as a hypothetical price, $500,000? Yes. Now we have 17 days to make sure we want to buy it for $500,000. Beautiful.
So maybe you can answer this for me, because you've been doing this a long time. You're an expert in the field. This is a crazy time because of the shortages.
Yep.
You know,
and it's not going away.
It's not going away.
I think we're going to be dead and gone. There's no way to dig out of it.
The appraisal process, I seem to remember it used to be like, I'm getting an appraisal to make sure I'm not overpaying for the property. I want a third party to tell me, hey, this is a good deal, right? But that's not really what the appraisal process is anymore, is it?
No, because, you know, within a certain margin, absolutely not. And you're right. The shortages have created a whole different dynamic, wherein the buyers are saying, look, we don't care whether it appraises for the price or not. We just want the house. So we're hoping, you know, if the sold comparables say 450, but we offered 475 because this house has, you know, an extra widget or a pool or something, they're hoping it does appraise for that. Because if it doesn't, then now there's only 4 possible scenarios if it doesn't appraise with that contingency. Seller reduces the price, buyer comes in with the difference in cash. You meet somewhere in the middle, or you kill the deal. And more oftentimes than not, because of the shortages, they don't want to kill the deal.
No,
they want to stay in the deal. So they're hoping. So really, the appraisal is, honestly, it's not even really protect the consumer. It's to protect the bank.
To protect the bank.
Yep.
And you think to yourself, then I've had clients afterwards, they're like, well, how did they sell me this house? The paint was peeling and this was bad. And I got an FHA loan. This shouldn't have happened. Why didn't the appraiser stop it? Because because at the end of the day, yeah, it may not have conformed to the guidelines, and that's not good for you. And you were hoping someone was going to say something or stop it. But end of the day, in step 2, you've got to be an adult, and you've got to say, "Do I want to buy this house?" I can see the paint's peeling. No one's coming to save you in this process,
Right.
and I think that that's the most important thing. Is I know there's housing is short, and it is difficult, but fixing houses is expensive. And, maybe it's a function of the fact that people just don't feel it as much anymore because they just never think they're going to pay the house off, or they've rented their whole life and they've never really been subject to repair costs. You're used to, hey, call them and they'll fix it. But like, what are you going to do if it's $12,000 to fix the septic? What are you going to do? I don't know.
Hey, you better hope you have the $12,000.
Yeah. So,
or you negotiate that during your due diligence, which,
yeah,
unfortunately, Dave, and where we lay blame is another. Gosh, I'd love to have you on to talk economics because you have such a brilliant economic mind. Where we lay the blame is not germane to our conversation. The bottom line is that we have we're now 15 years in of underbuilding homes. 15 years.
Wow.
So we would have to, for the next 15 years, overbuild to dig out of that hole.
Jeez.
I don't see it happening. So this is the new normal. We are going to be in this gridlock for the foreseeable future. I don't see anything on the horizon. I was talking to a guy today. He's like, well, if the government keeps going down the way it is, houses are going to go back down to 100 grand. I'm like, no, they're not. No, they're not, because we've got a shortage. That's the difference between this market and the one back in the early 90s and then in 2008, where you could argue there was an overage of supply. The builders were building them as fast as they could because the money was so free and fast and cheap and easy. Those days are long gone, and they're not coming back, at least not from what I see. Final thoughts?
Man, final thoughts that it is an exciting time, I guess, to be in real estate, and having a great agent, broker, God, can make all the difference. Did you know what the mean sales of the average broker is or agent?
Yeah, it's probably like 2 homes a year or something.
So, do you know? Do you know what the mean is? I think the mean isn't the mean the most. Maybe I need to check my old statistics. Is the mean the most recurring number, or is that the mode?
Oh, probably. Yeah, that would be.
Let's check that real quick.
Okay.
Mean, median, mode, because it's been a while. But I heard this stat. Let's see. The most frequently occurring number. Mean is the average of all numbers. Median is the middle number in order. Mode is most common. The mode of a real estate agent that you hire, the most frequently occurring annual sales number is 0.
What?
0.
Oh my gosh.
The most frequently
reported
number by a real estate agent is 0.
Oh,
so
man.
It is so important that people do realize that not everyone is Brian Hurst. Do your homework. Just because someone's your cousin and they also, do a great job repairing your cars and they have a real estate license, that may not be your guy on something this serious. Because there's performers, there's some okay performers, and then there's people that just have the license, they maintain it, they're smart, but they're not doing it. They're not doing this every day, and that's problematic. So that's my
who would ever hire an attorney to represent you and they've never done a deal, and like they they have 0 experience? That would be scary, right? It better be like a jaywalking ticket or something. Like you wouldn't want to hire that guy to represent you in a capital case or something.
No. So you have my permission to edit out the boring stuff.
We're live, buddy. There's no editing.
Okay.
All right. So if somebody has a legal issue and they need to contact you, there's a ticker down on the screen, is there somewhere better that they should go other than what we've provided?
That's the way to go. That the office functions best when we set the appointment, meet with you, and funnel it through the process.
Understand. Well, I love you, brother. You are a dear friend, dear brother. You mean the world to me. And, we've got history that brings out a certain amount of emotion in me concerning you personally, but I do appreciate you, and we look forward to having you on again soon.
Man, you do a great job with this. Love you very much, man. We'll
All right.
talk
Have
soon.
a fabulous day.
Bye.
David John Greiner, Esquire. Incredible man. Great legal mind. Hope that everybody learned something today about contracts, how not to get sued, and look forward to having him on again. Let's get to this week's market update. Before we do that, we encourage you to like, share, and subscribe to this channel, to the podcast. It helps us to spread the word and to help people in life and in real estate. Okay, let's look at this week's market update. This is June 19th, 2023. Last 30 days sold 357 homes, well below what would normally be happening this time of year. This is a function of both the higher rates, that's part of the issue, but the biggest issue is the low inventory. You can't sell a lot of homes if there aren't a lot of homes for sale. All right, I'm going to repeat that. You can't sell a lot of homes if there aren't a lot of homes for sale. Median sale price jumped up over the last week. Of those 357 homes that sold, these are single-family residences in Victorville, Apple Valley, Hesperia, Adelanto, Phelan, Oak Hills, and Hellendale, the 7 areas where most of our homes are sold here in the desert. $420,000. Incredible number. You would think, given market conditions, this number would have softened dramatically over the last 3 quarters. It did for a little bit, and now we are almost back to where we were 1 year ago when the homes were much more affordable vis-a-vis interest rates. Year over year, last year during this same 30-day period, we sold 442 homes. So we sold about 20% more a year ago than we did this year. But the price of the homes was only a little over 2% higher 1 year ago. They were 430,000 was the median sale price 1 year ago. In escrow, we have 614 homes. There's actually more homes in escrow than there are actively listed for sale at 569 homes. And our current interest rate, this is coming from Pride Stromsit for an FHA loan, 30-year fixed with a 660 mid FICO, 6 to 6.125%. All right, let's get to check this out. This week's edition of Check This Out. Hopefully this is something that'll help you. Something I learned about just this week. There is a website called govx.com, govx.com. And this website is catered to military, law enforcement, fire protection, emergency, medical, military families, and government employees. So essentially, if you're working in some precinct of the government, you would qualify. Now, for me, I'm an Air Force veteran. So I logged into the website. I went through and entered my service record, and they were able to find me in my service record and approved me for this website where you can go on and find discounts for things like tickets to Disneyland, tickets to Knott's Berry Farm, car rental, airfare, hotels, all kinds of goods and services, athletics, concert tickets, just incredible opportunities to save some money. So if you are a military veteran like me, or you've served in law enforcement like my dad did, or you're in the fire industry like my good friend Gilbert is, or you're in the emergency medical, or you're a military family member, whatever it is, government employee, it's something that maybe you could go on, save a little bit of money. Once again, we're just so grateful to Dave Greiner for coming on the show today and educating us and helping us to understand. That's it for today's broadcast, and we look forward to seeing you next week. In the meantime, we are serving your dreams. Have a wonderful week, everybody.